Hello everyone, welcome back to yet another session on the Meritshine Turbo series, which is helping you prepare for the SEBI Grade A and the RBI Grade B exams. The session today is focused on Companies Act and another very important chapter within Companies Act. So it is all the more relevant for SEBI Grade A aspirants. And what are we going to cover today? We're going to basically talk about share capital and debentures, which is nothing but chapter 4 of the Companies Act. And we're looking at sections 43 till section 72. Again, what we'll do is give you an overview of the chapter, look at the different titles of each and every section because that's going to give you a lot of insights about what that section talks about. So once we get a hang of what the section titles are and once you get an overview of the entire chapter 4, we'll look at a specific set of questions to help you understand and conceptualize chapter 4 and the sections pertaining to it in an even better manner. Another important aspect for you to follow as far as the sessions are concerned is whenever a question appears on the screen, pause the video, try to solve that question yourself, right? Apply your thoughts, apply your logic, apply your elimination techniques, solve the question. If you get the answer wrong, absolutely fine because I'm anyway going to be discussing the answer, right? But make sure that you attempt the question, try to solve it yourself before I attempt and show you what the correct answer is because that's where the real learning will happen. So what are we waiting for? Let's jump right in and discuss share capital and debentures from the context of Companies Act. So before we kickstart the questions, let's try and understand what exactly does chapter 4 deal with, and we're specifically talking about share capital and debentures. So this is what is predominantly being discussed as far as this particular chapter is concerned, and it basically looks at sections 43 to 72. So before we get into the question mode and try and answer questions from a conceptual standpoint, let's try and understand an overview of chapter number 4, which is share capital and debentures. Right, so basically your section 43 kind of talks about what are the different types of share capital, talk about your equity share capital, you're talking about your preference share capital, then what is the kind of nature of your shares and debentures gets covered in section 44. 45 basically talks about the numbering and 46 talks about the certificate of the shares and what are the signing authorities that should be there, those kind of things get covered. 47 talks about your voting rights. 48 essentially tends to cover the variation of any kind of shareholders' rights that might be there in different types of shares that could be there. Section 49, which basically talks about the different calls on shares of the similar class that can be there, okay, and the fact that it has to be on a uniform basis on that particular type of share, right? So whatever money is being called upon, it has to be called upon in that particular type or that particular class of shares on a uniform basis. That's what gets addressed in 49. Section 50 essentially talks about the idea that a company needs to accept the unpaid share capital, although it is not called up. So all the guidelines around that. 51 essentially talks about the payment of dividends, which is in proportion to the amount paid up. Okay. And 52 essentially talks about the application of premiums received on the issue of shares. Okay, then 53 talks about any kind of prohibition that needs to be there as far as the issue of shares at discount. Then 54 deals with sweat equity, another very important area to be discussed, right? 55 talks about the issue and redemption as far as your preference shares are concerned. 56 then talks about your transfer and transmission of securities. So let's say if you have possession of certain shares, how is the transmission and transfer of those securities possible? Then 57 essentially talks about any kind of punishment that is there for personation. We discussed this in the previous session as well, but this is more specific to your shareholders. That's the context. Then section 58 essentially talks about, let's say, the refusal of registration by a company for a particular member and what kind of action that the member can actually take against that particular refusal. Where does the tribunal come into the picture? All of these get covered in section 58. Section 59 essentially talks about the rectification of the register of members and corrections that are required that might be needed from time to time. Then you have section 60, which basically talks about the publication of authorized, and when you're publicizing the authorized capital, you also need to publicize simultaneously the subscribed as well as the paid up capital also at the same time. So that's the important criteria that gets discussed in section 60. Section 61 essentially talks about the power of a limited company to alter or change its share capital and all the kind of guidelines that are there around this. Then section 62 talks about the further issue of share capital. That's something which gets discussed here. Then section 63 talks about the issue of any kind of bonus shares that might be there. 64 deals with the notice that needs to be given to the registrar for any kind of alteration in the share capital. Section 65 talks about the unlimited company which needs to provide for the reserved share capital on basically your conversion into a limited company and the guidelines that are there around that. 66 basically deals with the reduction of share capital overall. right? 67 gets into the restrictions that are there on the purchase by a company. So essentially, when I'm talking about a purchase by a company, you're essentially referring to the process of buyback only, right? So whenever the company is trying to purchase, or let's say giving off loans, right, for somebody else for purchase of the company's own shares, then what are the guidelines that need to be followed? Now, section 70 also basically talks about the prohibition of buyback in certain circumstances. What are those circumstances in which the prohibition gets applied for buyback? That's get discussed in 70. Then 68 essentially talks about the power of the company to purchase its own securities, right? And 69 essentially deals with, let's say, transfer of certain sums which go into your capital redemption reserve account. So redemption obviously is from the act of redeeming certain shares. 71 exclusively deals with all kinds of debentures and the rulings around that, and then 72 essentially deals with the powers to nominate. So that's the overall context as far as this particular chapter is concerned. Now, if you think about it, if you're able to remember, or let's say even internalize the terminologies that are used to define each and every section. For example, we say that section 43 deals with the kinds of share capital. Or if, let's say, I talk about section 53, it says prohibition of the issue of shares at a discount, which means that whenever I'm looking to issue shares at a discount, automatically a prohibition kinds of applies, right? So if you read through the names of the sections multiple times, you'll be automatically able to figure out the basic context of what each and every section is going to be talking about. So once that clarity comes in, then by using logic and by using conceptual understanding, you'll be able to approach a lot of questions from that perspective and eliminate a lot of options. So which is where understanding what the section's title is becomes very, very important. And obviously, when you look at the context of a section title and then what is there inside that section, it will give you a lot more clarity in terms of what is expected out of that particular section pertaining to governance of corporate. So that's the overall context as far as the entire Companies Act is concerned, and more specifically in this case we're talking about share capital and debentures, which is chapter 4 and section 43 to 72. So now let's try and look at questions which can help us understand a lot of these concepts in a much better manner. So let's continue the session with the first question for the day, and I'll give you 30 seconds for you to pause the video and mark your answers. And here we go. What does it say? Section 43, which basically deals with the kinds of share capital, shan't apply to which of the following. So when I say shan't, it automatically refers to shall not, and in all probability the terminology that will be used will be shall not only. This is just for you to ensure that in case there is a difference in the wording that is given to you, you should not get confused. Okay. So what does this say? It says that section 43 obviously deals with the kinds of share capital, right? Now, in which of these situations will it not apply? That's what is the question, right? So will it not apply to a private company? And we're talking about the memorandum and the articles of association of the private company so provides. Okay. Then it talks about the specified IFSC public company. When I say IFSC, it essentially refers to your International Financial Service Center, right? So obviously this is one particular type of company which has been established in your IFSCs itself, right? So, and obviously it has certain kind of guidelines and restrictions that need to be followed. So if it is a specified IFSC public company wherein in the memorandum of association or the articles of association, it already provides for such kind of a scenario, then it will not be applicable. The third scenario is in case of a public company where the memorandum of association or the articles of association of such company provides for it. Now the point is, where will it not apply, right? So if you look at it, obviously since it is governed by the Companies Act and we're specifically talking about your SEBI as the regulator as well, so essentially you're looking at all your public companies that have to be definitely there. So section 43 definitely has to be applicable for your public companies, right? What are the exceptions? So when I'm talking about kinds of share capital, you're talking about your equity share capital, and there are other types as well which we'll discuss in the subsequent questions. But when I talk about specifically those kinds of capital, the section 43 and all the contents of it are not generally applicable to the private company or also to a specified IFSC as well. So in that case, both of these are kind of not required or let's say governed by section 43 of the Companies Act. So this is something which is important for you guys to remember. Section 43 and let's say certain sections within the chapter number 4, okay, will not be applicable to certain classes of companies, be it let's say your private companies, be it let's say your specified IFSC companies, or also some cases your Nidhi companies as well. So you have to be careful when you look at chapter 4 and look at very clearly what are the exceptions mentioned, right? And there are certain sections where your exceptions will be mentioned, and one such section is section 43, wherein your private company and your specified IFSC public company are not exactly part of it. Right? So that's something for you to remember. And in this case, option D as a result becomes my answer. Right. Let's now move on to the next question for today. Again, 30 seconds for you to pause the video and mark your answers. Here we go. So this also deals with the kinds of share capital, and the question is specifically, the share capital of a company limited by shares shall be of which kinds? So what are the kinds of share capital that we are talking about, right? So A is obviously a choice which is known to us. So it talks about equity share capital with voting rights, definitely there, right? Then we talk about option C, which is also very clearly known to us, that is your preference share capital. So the confusion will be in option B, wherein your equity share capital with differential rights is being talked about. Now the question comes in is that in this case, what do I mean by differential rights? So when I say differential rights, those differential rights could be towards voting, those differential rights could be towards your payment of dividend, or it could be in accordance with any other rules as may be prescribed from time to time. But definitely equity share capital with differential rights is also a kind of share capital only, which falls into the picture. So in that context, when I look at kind of share capital, automatically your option E becomes the answer in this case, wherein your equity share capital with voting rights, equity share capital with differential rights, and preference share capital, all of them are kinds of share capital only. So that gives us the answer as option E. Great. Let's now move on to the third question for the day. Again, 30 seconds for you to pause the video and mark your answers. Here we go. So essentially this talks about the equity shares with differential rights, which we discussed in the previous question. So what does the question say? No company limited by shares shall issue equity shares with differential rights, and these differential rights pertain to dividend, voting, or otherwise, unless that particular company complies with all of the following conditions except. So which of these 5 conditions is not mandatory to be complied with? That's the question here. So if I look at the options, the first one says Articles of Association of the company authorizes the issue of shares with differential rights. So obviously it's a no-brainer that your AOA should probably have this clearly mentioned. So this option should definitely be complied with. When I look at option B, what does it say? The issue of shares is authorized by an ordinary resolution passed at a general meeting of the shareholders, because you're not issuing a normal right equity share, but you're issuing equity shares with differential rights. It again makes logical sense to pass an ordinary resolution to define those differential rights. So again, B also makes a lot of sense. Now, if I look at option C, it says the voting power in respect of shares with differential rights of the company shall not exceed 50% of the total voting power, including voting power in respect of equity shares with differential rights issued at any point in time. So कहने का मतलब है कि 50% से ऊपर total voting power नहीं होना चाहिए, including the voting power that is there for equity shares with differential rights. So basically the contention here is this 50% the correct number or not? So I'm a little doubtful about option C. Okay, let's look at option D. It says the company has not defaulted in filing financial statements and annual returns for 3 financial years immediately preceding the financial year in which it is decided to issue such shares. So generally, whenever you're talking about filing of financial statements before a particular activity is happening, which is where it's saying immediately preceding, it is usually for a period of 3 years, right? And that's something which we do in our IT returns as well. So let's say if you're taking a housing loan or whatever it is, they generally ask you for the annual returns for the last 3 years. So similarly, this also seems to be a very logical option that is given, and ideally this should be adhered to as well. Next, I look at option E, which says the company has no subsisting default in the payment of a declared dividend to its shareholders. Okay, कोई default नहीं होना चाहिए, और repayment of its matured deposits. Fair enough, कुछ deposit अगर mature हुआ है तो उसका repayment भी जरूरी है. And then you're talking about redemption of its preference shares or any kind of debentures, which is referring to your debt that has become due for redemption or for payment of interest on any kind of such deposits or debentures that may have been there, or any kind of payment of dividend. So this again makes a lot of logical sense that unless I am a company which has not had any defaults with regards to any kind of dividend, any kind of redemptions, any kind of debenture interest payments, only then can I look at issuing such kind of differential right equity shares. So this also seems to be fairly logical. So my biggest confusion is with regards to this 50%. And since all the other options appear to be fairly convincing, even if I don't know what the exact percentage is, I will still go ahead and take the punt saying that option C should be my answer. Now let's try and see if whether option C is right or not. It is indeed. Okay. And what is that percentage that is expected? So this percentage shall not exceed 74% is what the ruling talks about. Now, if I go back, what does it say? It says shall not exceed 50%, and therein lies my problem that it cannot exceed 74%. That's the figure that I'm looking at. That is why option C becomes the option that is kind of incorrect out of all the other given options. Right. Let's now move on to the fourth question for the day. So again, 30 seconds for you to pause the video and mark your answer. Let's now look at the question. What does it say? A certificate specifying the shares held by any person shall be prima facie evidence of the title of the person to such shares, provided it is validated. So it's already saying that the certificate needs to be validated and it should carry one of these. Okay, let's try and see what the options are. Issued under the common seal, if any, of the company. Right? Earlier, the common seal was something which was mandatory, but with the latest rulings, it says common seal, if any, of the company. Then it says signed by 2 directors, and option C says signed by a director and the company secretary. So obviously the assumption here is that the company has appointed a company secretary as well, right? And option D says any of the above, and option E says all of the above. So what's the difference between option D and E? Option D says if A, B or C, if any one of these 3 is available, then that certificate will be considered as valid, right? Whereas option E says that it has to be A plus B plus C, which means it has to have the common seal, it has to be signed by 2 directors, and it has to be signed by director and the company secretary, right? That is what option E refers to. So if I think purely from logic, ideally if one of these 3 is available, automatically the certificate should be valid, right? So obviously it cannot be both B and C because it seems counterintuitive, right? Because if it is signed by 2 directors, why will I again sign by director and the company secretary? It does not make much sense. And generally, when you have a common seal already in place, then your signatures might not be required. So in the context of that, if I look at this particular question, if any of A, B or C is available, automatically the certificate would be considered as valid and it would be a prima facie evidence of the title of the person. If it has a common seal, or it is signed by 2 directors, or it is signed by a director and the company secretary, right? So that's the context as far as this particular question is concerned. Let's see if we have got this answer right or wrong. Absolutely right. Okay, so let's move on to the 5th question for the day. Okay, so 30 seconds for you to pause the video and mark your answers, and here we go. This is basically related to section 48 and deals with the variation of shareholders' rights. So let's try and read through the statement very quickly. It says where a share capital of the company is divided into different classes of shares, the rights attached to the shares of any class may be varied with the consent in writing of the holders. So basically what I'm saying is if there are any changes to be made or any variations to be made, कुछ भी change करना है, तो उसके लिए जो consent है, वो basically writing में obtain करना होगा from whom? From the holders of such shares, right? Now the question that's being asked is what fraction of those holders should be required in order to ensure that it is treated as valid. Okay, so and this can also be done by means of a special resolution passed in a separate meeting of the holders of the issued shares of that class, right? Now the other point here is where the holders of not less than dash of the issued shares of a class did not consent to such variation or vote in favor of the special resolution for the variation, then they may be applying to the tribunal, right? And whatever is the variation that has been applied to, they can basically ask the tribunal कि भाई हमसे बिना पूछे या हमारे बिना consent के
ये वेरिएशन बोला गया है, ये वेरिएशन किया गया है, राइट? एंड where such application is made, the variation shall not have effect unless and until it is confirmed by the tribunal. So once they reach to the tribunal, it's up to the tribunal whether they want to accept that variation or reject that variation, right? Now, the other point here is provided that an application under this section shall be made within dash days, which means whatever percentage of those people who are against this variation, they need to make that application within dash number of days after the date on which the consent was given or the resolution was passed. Now, whichever the case may be, and they may be made on behalf of the shareholders entitled to make the application by such one or more of their number as they may appoint in writing for this purpose. Means that it's not necessary that all the percentage of the applicants or the holders who are not in favor of the variation, not all of them need to make the application, right? So they can basically appoint one or more members out of those given lot of shareholders who will act on behalf of those remaining shareholders. So that's the context. So the question that comes in is, what is that fraction? Is it 3/4 of the issued shareholders, or is it 2/3 of those shareholders? The next question that comes in is it 10% or is it 15% of the issued shares who did not give consent, and then only they can go to the tribunal? And the final consideration is it 15 days or is it 21 days? So these are three variations that we need to look through, right? So if we go again by a little bit of logic, right? Whenever I'm trying to pass a resolution which has some changes, right, or which has some variations, I would ideally need to get consent from as many of the shareholders as it is impacting. So if I go by logic, what I'm looking at is I should get the consent from as many as possible. So I'll probably look at 3/4 of those holders of shares, or roughly 75% giving their consent, right? That's what I'm looking at. That's the first target. Now the next question that follows by logic is, how many of these people do not need to consent, right? Now, if I say that 15% of the shareholders have a problem with this, right, which means that at least 15% होने पड़ेंगे तभी तुम उस वेरिएशन को ट्राइब्यूनल के पास ले जा सकते हो. So here also I'm trying to protect the interests of the minorities, right? So a minority of 10% is less than the minority of 15%, which means that at least if there are 10% of the shareholders who did not consent to such variation, then that is good enough to reach out to the tribunal, right? Instead of 15%, only 10%. अगर 10% भी ये बोले हैं कि they are not okay with it, then they can go and reach to the tribunal. So obviously, again, purely by logic and with the thought of protecting the shareholders' interest, 10% appears to be more logical than 15%. Thinking from that context, automatically my option B becomes my correct answer already, right? And again, if I look at logic, instead of giving these 10% holders who did not consent just 15 days, I am giving them 21 days to basically file their application, right? That's the context. So again, I'm giving them more time as well. So whenever, I said in the previous session as well, whenever it is requirement of time from the public, then you tend to give more time to them so that they have enough time to act on whatever is to be done, right? So in that context, 3/4 is the number that we're looking at. At least 3/4 or not less than 3/4 of the issued shares should provide the consent in writing, right? If not less than 10% of them did not consent to it, then they will basically get 21 days to make the application. So that's the overall context, and that indeed will be my answer. So let's move on to the sixth question for the day. 30 seconds for you to pause the video and mark your answers. And here we go.
So this one deals with section 50, which is talking about your unpaid share capital and the capital which has not been called up. Okay. So in this case, it's asking, pertaining to section 50, which of the following statements is or are true. Okay. So it's asking for the true statements in this case. Now, a company may, if so authorized by its articles, accept from any member the whole or a part of the amount remaining unpaid on any of the shares held by him or her, even if no part of that amount has been called up. So called up in the sense the company has asked for that amount. So what it basically is saying is that even if that particular amount has not been called up, if there is any unpaid amount, right, and if the company is authorized by its AOA, then it can look at accepting from any member the remaining or the whole amount itself. So that is what this first point talks about. What does the second point say? It says a member of the company limited by shares shall be entitled to voting rights in respect of the amount paid by him or her under subsection 1 of section 50, even though that amount has not been called up. Okay. So now, from a company standpoint, it does not make sense to give voting rights to a person for the portion that has not yet been called up. So there's one thing which is not making any sense. Now, if I very carefully read option 1, it says accept from any member. So in this case, it's again the company is not demanding its members to pay any amount which has not been called up. Okay. They're not demanding. But if a member wants to pay, then they're okay to accept that amount from such member, whether it's a whole amount or a part amount of the remaining unpaid portion. So here, there is no obligation on part of the member because the company is not demanding, but the company is only accepting. So if I look at the technical language used, I am convinced that one is definitely possible, right? But if I look at logic, so if the amount has not been called up, so whatever is the amount that has actually been called up, the voting rights should be applicable only for that portion, right? That's what makes logical sense. Right? Just because a member is paying an amount in advance does not mean all the other members have to suffer because of that, right? Because the amount has not been called up already, right? So in that sense, while a member is allowed to pay additional and the company is okay to accept it, if that person pays additional, it does not mean that he will get additional voting rights, right? So that is what is the logical thought process here. Now, what is it being asked? Which of the ones is actually true? So in this case, by pure logic, only option 1 should be true, and that indeed will be our answer. So what is the correct language in this case? The correct language is the member of the company limited by shares shall not be entitled to any voting rights under subsection 1 of section 50 until that amount has been called up, right? So that's the clarification. Okay, let's move on to the next question for the day. As always, 30 seconds for you to pause the video and mark your answers. And here we go. So this one basically deals with section 51, which talks about dividend on the amount paid up, right? So the question is, which of these following statements is or are false? That's the context that needs to be applied. So the statement 1 says, a company may, if so authorized by its articles, pay dividends in proportion to the amount paid up on each share. Okay. Then second, a company will pay dividends in proportion to the amount paid up on each share. And third, a company won't pay dividends in proportion to the amount paid up on each share until the complete amount due is paid up. Now, whenever you get words such as will pay and won't pay, it's like saying with certainty that something will happen or something will not happen, right? And as far as the Companies Act is concerned, you'll always have some gray area, right? So when I say gray area, instead of words like will and won't, you may also find words such as may and may not, right? That's the context. So if I go by pure logic, right, to say that a company will pay dividends in proportion to the amount paid up on each share is like sounding as if this is something which is mandatory. Whereas if I look at option 1, it says a company may, and it's also additionally stating that if it is authorized by its articles of association, only in that condition it may pay dividends in proportion to the amount paid up on each share. Now, dividends in proportion to the amount that has been paid up on each share makes a lot of sense, right? जितना pay up हुआ है उतने में ही proportion में dividend मिलना चाहिए. That makes a lot of sense, right? So logically, statement 1 makes a lot of sense. But the problem with statement 2 is that it is passing a 100% surety kind of a thing, whereas option 1 gives the company a chance to pay or not to pay also, right? Now, option 3 is also quite tempting, where it says that it won't pay dividends in proportion to the amount paid up till the time the complete amount due in terms of what is to be paid up is actually obtained by the company. So the problem in that case is that, let's say if you've only called up, let's say 70% of the amount, so obviously 30% will be balanced, it will not be paid up. So if you have not called up that particular amount, why should the shareholder pay the price for that, right? So ideally you should end up paying the dividends for whatever is the amount that has been paid up till now, and rather than waiting for the amount due to be completely paid up. So as a result, option 3 is something which is not good for the shareholders. As a result, this does not make logical sense, right? And again, because option 2 makes it a certain case, as a result, that's also not the correct option, right? And also does not specify anything with regards to the authorization present in the articles of association. So as a result, your option 2 and 3 are the ones that are false or incorrect, and that will be my answer. Great. Let's now move on to the 8th question for the day. As always, 30 seconds for you to pause the video and mark your answers. Okay. This one basically looks at section 52, right? And that is referring to your application of any kind of premia or premiums received on the issue of shares, right? Now, don't get hassled by looking at the size of the question, right? Because it's the Companies Act, you'll always find questions that are going to be quite big, right? So how do we break down such questions? So let's try and understand. It says where a company issues shares at a premium. So you observe a comma here, right? Look for the next comma. This one. So break that sentence down into multiple parts. So where a company issues shares at a premium, okay? Now whether that premium is for share or for otherwise, right? In that case, a sum equal to the aggregate amount of the premium received on those shares shall be transferred to the securities premium account, right? Jitna bhi premium amount mila hai over and above the actual face value, that needs to be transferred to the securities premium account, right? And the provisions of this act relating to the reduction of share capital of the company shall, except as provided in this section. Again, so this can be read separately. Look at this comma and then look at this comma, right? So you can see reduction of share capital of a company shall apply as if the securities premium account were the paid up share capital of the company, right? So notwithstanding anything contained above, which refers to all of these 5 lines, the securities premium account may not be applied by the company towards which of these following, right? Which means जो पैसा आपका securities premium account में है, उसको आप किस चीज के लिए utilize कर सकते हो? So when I say application of the amount, it is referring to where all can it be used. So if I look at option A, it says issue of the unissued shares of the company to the members of the company as fully paid bonus shares. So obviously you're talking about bonus shares, right? And also to the members of the company. So in this case, looks to be quite logical, right? Second, it says writing off the preliminary expenses of the company, कुछ भी खर्चा वर्चा हुआ है, right? Or the expenses of, or the commission any that would have been paid, or any kind of discount that was allowed on any issue of shares or debentures of the company. So anything that has been incurred as an expense on the issue of shares or the issue of debentures for the company, technically writing off such expenses, this amount in the securities premium account can be used. Again, seems to be fairly logical. Look at option C. It says providing for the premium payable on the redemption of any redeemable preference shares or of any debentures of the company. Again, किसी भी preference share के लिए, generally your preference shares have to be redeemable, right? So what is the premium that needs to be paid on the redemption of such preference shares or any kind of debentures? Ideally इसके लिए भी allowed होना चाहिए. Makes logical sense here as well, right? Look at option D. The purchase of its own shares or other securities under section 68, wherein the buyback is more than 25% of the aggregate of the paid up capital and the free reserves of the company, right? So from logic, it is fairly clear that A, B and C make a lot of sense. So the answer has either got to be D or none of the above. Now, where all can D go wrong? There are two possibilities. Either the section could be wrong, or the amount could be wrong, or both could be wrong, or both could be right. Now, if I have to take a risk, in this case, what I will do is I'll go ahead with option D, assuming that something might be incorrect in this, right? So obviously there is a risk involved here. But if I read the section 52 very carefully, it essentially talks about some very clear aspects. So what it says is that essentially when you're looking at this particular question, you're talking about the purchase of its own shares. If you remember in the beginning of the class, I had talked about all the sections and I talked about section 68 as well, which is obviously dealing with the buyback, right? So the section definitely is correct, right? Now, if I again look by logic, right? If the company wants to purchase its own shares or other securities under section 68, wherein the buyback is more than 25%. So if the buyback is more than 25%, that's a significantly large amount of buyback, right? So usually the limit in this case is 25% or less when you're talking about the aggregate of the paid up capital and the free reserves, right? And it will be 10% or less when you're talking about the total paid up equity capital and free reserves. So that is the consideration or the limit that you should be aware of, right? So if the company decides that the purchase of its own shares of other securities is the purpose for which your securities premium account needs to be used as per section 68, then the buyback has to be for 25% or less in terms of the aggregate of the paid up capital, right? And 10% or less in terms of the total paid up equity capital and the free reserves of the company. So this is something that you should remember. So in this context, risk that I took in terms of option D being the option for which the securities premium account cannot be applied turns out to be correct in this case, right? So remember this, 25% or less of the aggregate paid up capital and 10% or less in terms of the total paid up equity capital. That's the context, and in both the cases you have the free reserves of the company, right? Okay, let's move on to the 9th question for the day. Again, 30 seconds for you to pause the video and mark your answers. So this one basically looks at section 53, which is talking about the issue of shares at discount. Now, if you remember the title of that particular section that I showed you in the beginning, it talked about the prohibition of issue of shares on discount, right? So if you had remembered that section title, solving this question would become a lot more easier, right? Now, what does it say? Which of the following statements regarding section 53 dealing with the issue of shares at discount is false, right? What does it say? A company may issue shares at a discount to its creditors when its debt is converted to shares in pursuance of any statutory resolution plan or debt restructuring scheme in accordance with any guidelines or directions or regulations specified by the RBI under the RBI Act or the Banking Regulation Act of 1949. This is what is being talked about as far as option 1 is concerned. Now the big question is, what is the difference between option 1 and option 2? The only difference is it governed by SEBI or is it governed by RBI? That's the funda. So one of these has to be definitely false, right? That's the question. Now what I need to figure out from there is whether option C is correct or incorrect. What does option C say? Now, where any company fails to comply with the provisions which have been mentioned in section 53, such company and every officer in default shall be liable to a penalty which may extend to an amount equal to the amount raised through the issue of shares at discount, or 5 lakh, whichever is less, and the company shall also be liable to refund all monies received with interest at the rate of 12% per annum from the date of issue of such shares to the person to whom such shares have been issued. Now here, if I look at option C, an amount equal to the amount raised through the issue of shares at discount makes logical sense. So the confusion here could be with respect to the amount pertaining to 5 lakh or the rate of interest pertaining to 12%, right? So if I look at which of these statements is false, right? When I talk about creditors, right, it is referring to some stuff which is pertaining to your assets and liabilities, right? More specifically, it is dealing with some kind of a lending or some kind of a debt, right? So in that context, it makes more sense for the governing authority to be RBI rather than SEBI in this case. So your option B is definitely incorrect. The second thing which I need to check is it only option B or is it both B and C? So that will be the big confusion in this case, right? So generally, if I look at it, the fines have been around 5 lakh, that is true, and the rate of interest is 12% in case of any penal interest that is being charged. So not always, but this is something which is happening in many such scenarios, right? So as a result, in this case, a slightly tricky question wherein you may be tempted towards both B and C, but that would have been an incorrect option because technically option C is correct, right? So the penalty amount is equal to the amount raised through the issue of shares at a discount or rupees 5 lakh, and it clearly saying whichever is less, right? And the rate of interest would be 12%. So option C in this case is correct, which means option E also gets eliminated, and since A is also correct, option D also gets eliminated. So the only option that's there in this case is option B, and that indeed will be my answer. Important thing for you to understand here is, if you look at the first statement of this particular section, it very clearly calls out that any share issued by a company at a discount price shall be void, which means ideally you should not be issuing shares at a discount at all unless one of these scenarios is happening, right? And if it fails to comply, these are the penal provisions that will get applied to the company and the people involved in the default. Okay, let's move on to the next question for the day. Again, 30 seconds for you to pause the video and mark your answers. Okay, this one basically talks about section 54, which is basically referring to the issue of sweat equity of shares, right? Now, what do I mean by sweat equity? मतलब किसी ने कुछ मेहनत की, उसके लिए आप उसको पैसे दे रहे हो. Somebody has sweat for your company and you want to basically allocate some shares to that person or that individual or a group of individuals. That's the sweat equity. Now, when I look at the question, it says a company may issue sweat equity shares of a particular class of shares already issued if the following conditions are fulfilled. So, which is the condition that is not required to be fulfilled? So again, if you look at it, the issue has to be authorized by a special resolution passed by the company. Makes a lot of sense, right? The resolution specifies the number of shares, the current market price, what is the consideration or the amount, if any, that is there, and the class or the classes of the directors or employees to whom such equity shares are to be issued. Now, when I say classes, it essentially refers to the type of that employee. Is it a permanent employee, and which particular designation does that employee belong to, right? What type of directors are they? So all of those things have to be clarified. So this again appears to be quite logical overall, right? Now let's look at option C. What does it say? Option C talks about the fact that not less than 1 year has, and again, as I said, remember the comma whenever you get confused. So if you read the sentence not less than 1 year has at the date of such issue, it sounds a little confusing, right? So just look at this as something that is mentioned in a bracket, right? So not less than 1 year has elapsed since the date on which the company had commenced its business, right? So not less than 1 year since the date of such issue. That's what you're trying to say, right? So this seems to be a problematic clause because if you talk about startups, then if they've not commenced business 1 year prior, that means they will not be able to issue sweat equity shares. So that kind of makes it a little weird, right? So not sure if this will be true or not. Let's look at option D also. It says where the equity shares of the company are listed on a recognized stock exchange, the sweat equity shares are issued in accordance with the regulations made by SEBI in this behalf. And if they are not so listed, the sweat equity shares are issued in accordance with such rules as may be prescribed. So whenever you bring in such rules as may be prescribed, this is a common language used across Companies Act, right? So in that case, most of such options will be correct, right? So with such rules as may be prescribed, basically kind of brings in some conditionalities, right? Now what those conditionalities are will be possible for you to understand when you click on this as may be prescribed in the Companies Act itself, right? But what I understand is whenever it is talking about in compliance with SEBI, in compliance with such rules and regulations, the chances of such an option getting wrong is fairly less. So ideally option D is also correct. Now either option E is my correct answer or option C, right? Now the reason why I go for option C in this case is that if I'm talking about more than 1 year having been elapsed since the commencement of business, then it might be too much of a time as far as startups are concerned, and they may want to issue sweat equity shares much earlier. As a result, by pure logic, I look at option C as my correct answer. Right? Now, what exactly has happened as far as this particular section is concerned? Within this section, this was available as one of the clauses earlier, but pertaining to the Companies Amendment Act 2017, this particular point, that not less than 1 year has elapsed since the date on which the company has commenced its business, this particular point has been omitted from this section, right? So that it becomes more relevant for your startups as well, right? So that is the context in this case, and that's why your option C is the one which does not require to be fulfilled. Okay, let's move on to the next question for the day. What does it say? 30 seconds for you to pause the video and mark your answers. This one basically pertains to section 55, which talks about the issue and your redemption of your preference shares, right? Now, the question is, which of the following statements regarding section 55 dealing with issue and redemption of preference shares is false, right? Let's look at the options. A company limited by shares may, if so authorized by its articles, issue preference shares which are liable to be redeemed within a period not exceeding 20 years from the date of their issue. Okay. The only problem that I might possibly have with this option is 20 years. Okay. Then if I look at your second option, what does it say? No such shares shall be redeemed except out of the profits of the company, which would otherwise be available for dividend, or out of the proceeds of a fresh issue of shares made for the purposes of such redemption, right? So technically, only the profits and let's say a fresh issue meant for such redemption can be used in order to redeem such preference shares. This seems to be quite logical. C says no such shares shall be redeemed unless they are fully paid, right? Redemption should ideally not happen unless all the money that was supposed to be received on them has been received. So this again makes a lot of logical sense. If I look at option D, it says where such shares are proposed to be redeemed out of the profits of the company, there shall, out of such profits, be transferred a sum equal to the nominal amount of the shares to be redeemed, and this needs to be put across in a reserve which will be known as your capital redemption reserve account, and the provisions of this act relating to reduction of share capital of a company shall apply as if the capital redemption reserve account were paid up share capital of the company, right? So technically, if you remember the securities premium account and creating that separate account, in a similar context, you are saying that the sum equal to the nominal amount of the shares to be redeemed has to be moved to a reserve called as the capital redemption reserve, right? Which again makes a lot of logical sense again. And if you look at the terminology also, it appears to be highly technical. So this again appears to be a correct option. So the only option that could go wrong is option A, or it could be option E, right? So I'm tempted to go towards option A because I'm assuming there has to be some exception to that 20-year rule that is there. Okay, let's try and find out the answer. Yes, indeed, there is an exemption to that 20 years. So let's try and understand what is the correct way of framing the statement, right? So when I have a statement like this, what it does is that it makes me believe that the period cannot exceed 20 years at all from the date of the issue of such preference shares, right? But it is not really mentioning the basic clause that is supposed to be added at the end, which is subject to such conditions as may be prescribed, right? Now, why is this particular clause important, right? Because if this clause is added, it automatically means that in most of the cases, it cannot exceed 20 years, but there could be some conditions where it could exceed 20 years also, right? Which is where it's important that this particular clause be there. Now, if I want to understand what exactly is the condition in this case, the condition is that provided that a company may issue your preference shares for a period exceeding 20 years, right? And this is specifically meant for your infrastructure projects. So if you are issuing preference shares for infrastructure projects, subject to the redemption of such percentage of shares as may be prescribed on an annual basis at the option of such preferential shareholders, then for such infrastructure projects, your greater than 20 years is definitely possible, right? So that is where option A went wrong. So while all the language was correct, a critical condition that was available wherein it can be allowed to exceed 20 years was basically omitted in this particular section. And if it was omitted, then at least this line should be mentioned, subject to such conditions as may be prescribed. Now, what are the conditions that may be prescribed? The prescribed condition is provided that for infrastructure projects, it can be greater than 20 years, right? Even if this line is mentioned and infrastructure projects itself is not mentioned, your option A still becomes correct, right? But without this portion marked in red, your option A will turn out to be incorrect because there are certain conditions available, right? So I hope this is clear to you guys as to why option A is actually false in this case, right? Now let's move on to the next question for the day. Mark your answers. Okay, so what does this one talk about? This is talking about section 59 and it's talking about the rectification of the register of members. Again, too big a statement to start with initially. So what could be the way to approach these things, right? So again, whenever you're referring or reading a bare act, you'll always find there'll be a lot of commas in between. There'll be a lot of technical jargon. So how do I eliminate those things, right? So look at all the possible commas that are there, right? And look at the information which is important, which is critical, that needs to be read and which can be not read. That's the whole idea. So if I look at this, if the name of any person entered in the register of members of a company is omitted therefrom, or if a default is made, the person aggrieved or any member of the company or the company may appeal in such a form as may be prescribed to the tribunal or to a competent court outside India. So that is what is the crux of this. All of the other things which I have not read, which is without sufficient cause, again without sufficient cause, right, after having entered into the register, right, all of these, or unnecessary delays, all of these are basically only explaining what was available just before them in form of the comma, right? So whenever a comma comes into place, it is only going to try and explain what was there earlier, right? Similarly, when I talk about a competent court outside India, कौन सा कोड भाई, वो वाला कोड जो सेंट्रल गवर्नमेंट ने स्पेसिफाई किया है in their notification. And when will this be applicable? When you're talking about foreign members or debenture holders which are residing outside India, right? For the rectification of the register. So if you read it in silos and if you look at the commas carefully, this huge statement which is of 7-8 lines can be broken down into 3 to 4 lines. You're with me? Right? And it makes it a lot more easier for you to grasp and understand. And that's the way you need to look at. So basically ये पूछा जा रहा है इस question में कि if there is a default that happens with the order that has been given by the tribunal, what exactly will happen, right? So if I look at the options in this case, what happens here is the company shall be punishable with a fine which shall not be less than 2 lakh but may extend to 10 lakh, 1 lakh, 5 lakh, 1 lakh, 5 lakh, 2 lakh, 10 lakh. These are the amounts that are mentioned, right? Now, in one case, you're talking about an imprisonment which may extend to 1 year. In another case, you're only talking about a fine which shall not be less than 1 lakh but which may extend up to 3 lakhs. In one case, you're talking about a fine as well as an imprisonment. In the last case also, you're talking about both an imprisonment as well as a fine where the amounts are slightly different, right? So these are the 4 combinations given to you, right? So this question is definitely a bit tricky, right? Because you may be tempted towards choosing one of these options, but the correct answer in this case is none of the above, right? What is the reasoning behind that? Let's try and understand. So what exactly happened in this particular case is that this particular statement or clause was actually a part of section 59, right? But it was omitted by the Companies Amendment Act of 2020. So as late as 2020, this particular statement was removed, right? So what it essentially entails is that while this clause was there earlier, and this is actually the correct clause which talks about 1 lakh amount and 5 lakh and an imprisonment which may extend to 1 year or with a fine that shall not be less than 1 lakh but which may extend to 3 lakh. All of this makes logical sense. Company का fine जो है 1 से 5 lakh, individual persons का fine जो है 1 lakh से 3 lakh, and basically an imprisonment up to 1 year, right? And it can be a fine as well as imprisonment. Both can be possible. So this was the initial clause that was there. Now, this was technically removed in 2020. Probably the governing body felt that this is too much of a punishment for a rectification of the register of members, right? And there's one more clause in this particular section which basically talks about in case there is something that is happening in contravention to any of the provisions of, let's say, the SEBI Act or this particular section, then in that case, the tribunal may, on an application made by the depository or the company or the depository participant or the holder of the securities or by SEBI itself, it can direct any company or the depository to set right or make the necessary changes that are needed, okay, to rectify the register of the records concerned, right? So tribunal can basically pass an order to that effect, right? So as a result, because this is only the rectification of the register of members, a penal code according to, let's say, the governing bodies did not make too much sense. That is why this amendment came about in 2020, wherein this clause with regards to the penalty was completely removed. And whatever is the contravention or whatever needs to be corrected, the tribunal can pass an order to ensure that such corrections can be carried out, right? That's the idea. Okay, let's try and move on to the next question for the day. 30 seconds again for you to pause the video and mark your answers. This basically pertains to section 62, which is your further issue of your share capital. So what does the question say? The company shall not make a provision of money for the purchase of or subscription for shares in the company or its holding company if the purchase of or the subscription for the shares by the trustees is for the shares to be held by or for the benefit of the employees of the company, right? Unless it complies with the following conditions. So whenever you are basically provisioning money for the purchase of or for subscription for shares in the company or the company's holding company, and this is basically meant for the employees of the company and it is held by a trust, right? So in that situation, what all are the things that need to be complied with and what are the things that are not required? And we are looking at what is not required to be complied with as far as this question is concerned. So what does it say? Such purchase of shares shall be made through a recognized stock exchange or by way of private offers or arrangements in case the shares of the company are listed, right? Option B says where shares of a company are not listed on a recognized stock exchange, the valuation at which shares are to be purchased shall be made by a registered valuer. So I have a bit of a problem with both option A and B, right? Seem to be contradicting. Now A says it's okay if it is made through recognized exchange, and also if it is through private offers or arrangement, then also it is okay, right? But you're talking about shares of a company that are listed. So if it is listed, then ideally it should happen only on the recognized stock exchange, right? That's the problem with option A. And it is contradicting option B also, because when shares of a company are not listed, then ideally it should be valued by a registered valuer. So B makes a lot of sense, right? So as a result, A contradicts B. So there is something wrong with A, right? Let's look at option C also. It says the scheme of provision of money for purchase of or subscription for the shares as aforesaid is approved by the members by passing a special resolution in a general meeting, which also makes a lot of sense, right? This is quite logical. If I look at D, the value of shares to be purchased or subscribed in aggregate together with the money provided by the company shall not exceed 5% of the aggregate of the paid up capital and free reserves of the company. So in this case, this is basically meant for the employees of the company. The other case which we saw, which was the 10% and the 25% was towards the buyback. So that's a different scenario. Here it is 5%. So the confusion could be between option D and option A. But I'm sure that if option B is correct, option A definitely cannot be correct, because when I'm talking about a listed company, private offers or arrangements should not ideally happen, right? So if option A is definitely incorrect, I will still go ahead and take a risk with option D, assuming that 5% will be the actual number, because this is the only confusion area, whether it is 5% or less or more, right? So as a result, since only one of these has to be incorrect, I will go ahead with option A. And that indeed is my correct answer. What is the change here? So in case such shares are to be purchased, it can happen only through a recognized stock exchange, right? In case the shares of the company are listed, and not by way of private offers or arrangements. And this 5% is actually the correct figure as far as the value of the shares are concerned, pertaining to what is being held by or is held for the benefit of the employees of the company. So that's the percentage applicable in that case. Okay, let's move on to the 14th question for the day. 30 seconds for you to pause the video and jot down your answers. So this one basically pertains to section 67. Restrictions on the purchase or giving loans by a company for the purchase of its own shares. Right? So what does the question say? No public company shall give, whether directly or indirectly, and whether by means of a loan or a guarantee, the provision of security or otherwise, any financial assistance for the purpose of a purchase or subscription made or to be made by any person of or for any shares in the company or in its holding company, except when, which means public company किसी भी हालत में कोई लोन गारंटी या कुछ फाइनेंशियल असिस्टेंस प्रोवाइड नहीं कर सकता. इट कैन नॉट गिव अ लोन और अ गारंटी और अ फाइनेंशियल असिस्टेंस एक्सेप्ट इन one or more of these conditions. Let's try and understand those conditions. It says the lending of money is by a banking company in the ordinary course of business. Yeah. So if it's a loan or a guarantee being provided by a banking company, then it should be allowed, right? Because it's the ordinary course of business for such company, right? Because it's a banking company. So this makes logical sense. If I look at option B, it says the provision by a company of money in accordance with any scheme approved by the company is through a special resolution and in accordance with such requirements as may be prescribed, subscription for fully paid up shares in the company or its holding company if the purchase of or the subscription for the shares held by trustees is for the benefit of the employees or such shares held by the employee of the company. So if it is meant for the employees of the company, then it makes a lot of sense, right? So while it's a blanket statement, I'm okay to go ahead with it because it clearly mentions in accordance with such requirements as may be prescribed, which means automatically all the conditionalities get covered here. So I'm happy with option B as well. Let's look at option C. What does it say? The giving of loans by a company is to persons in the employment of the company other than its directors or key managerial personnel for an amount not exceeding their salary or wages for a period of 1 year with a view of enabling them to purchase or subscribe for fully paid up shares in the company or its holding company to be held by them by way of beneficial ownership. So overall, this option also seems to be fine. The only caveat in this option could be period of the salary portion, right? So will it be 1 year, will it be 2 years, or will it be less than 1 year? मतलब कितना portion है of the amount in terms of their annual salary? That's the whole context, right? उतने level तक का आप loan दे सकते हो as a company. So that is the extent of loan that you can give as a company. But for what portion, what can that amount be? So that is where the question comes in. So since I'm very sure about A and B being correct, so option which does not fit in has to be option C, right? So technically, while you cannot give any loan or guarantee, it is okay as long as it is a banking company. It is okay as long as it could be your employees when it is held through a trust and a special resolution has been passed and all the necessary conditionalities have been fulfilled in accordance with such requirements as may be prescribed. The problem with C is I have a doubt in terms of the duration. What is the amount that is allowed in that case, right? What does option D say? It is either A or B. And option E says that it is either B or C. So I know for a fact that A has to be there definitely as an exception, right? So definitely option E also gets eliminated, right? So since I'm not so sure about option C, so the option that I'll go ahead with is option D, which is the case is either A or B. Right? So whenever it is lending through a banking company or whenever all the provisions are being met as may be prescribed through a special resolution and it is for the benefit of employees, in both these situations, it is okay for the public company to give a loan or make the provision for such security. Okay. So why is option C wrong? Let's try and understand that. Option C is wrong because the amount shall not exceed their salary or wages for a period of 6 months, right? That's why your option D becomes the correct answer in this case. Okay, let's look at the final question for the day. 30 seconds for you to pause the video and mark your answers. So what does this one talk about? This is basically looking at section 70, which is the prohibition for buyback in certain circumstances, right? So what does it say? No company shall directly or indirectly purchase its own shares or other specified securities, okay, through any subsidiary company, including its own subsidiary companies. I think it makes a lot of sense. It should not buy through them. Through any investment company or a group of investment companies. Again, makes a lot of sense. If a default is made by the company in the repayment of deposits accepted either before or after the commencement of this act, interest payment thereon, redemption of debentures or preference shares or payment of dividend to any shareholder or repayment of any term loan or interest payable thereon to any financial institution or banking company, right? So basically, in case there is any kind of a default in any of these things, even then the company should not be allowed to purchase its shares, right? Again, seems to be fairly logical. If I look at option D, it says in case such a company has not complied with the provisions of section 92, 123, 127 and 129 of this particular Companies Act, right? So what could be wrong here is the naming or the numbering of the sections in this particular case. But I'm actually looking at all the options and I know for a fact that A, B and C are definitely correct. So I need to have A, B and C in my answer. Now only D cannot be my correct answer. So even if D is incorrect, I need to have A, B, C as the correct answer, right? Which means I'll go with E, which is all of the above. By logic, I've applied that since A, B and C are definitely true and will form a part of this particular statement, automatically option D has to be correct as well. And that is why the answer in this case will be all of the above. Right? So which means no company shall directly or indirectly purchase its own shares or other specified securities through subsidiary or own subsidiaries or through any investment company or a group of investment companies, or if there is a default or in case it is not complying with the provisions of these specific sections. Now, why did I highlight these sections? Because it's important that you have a look at these sections as well so that it brings in some more clarity in terms of what exactly is required, right? That's the reason I had given this particular question. Okay. So the answer in this case is all of the above. So what would help is if you look at these sections also and gain some more clarity on that front. So I hope you enjoyed this particular session, which basically dealt with share capital and debentures and specifically talked about chapter 4 of the Companies Act. Again, a very important chapter in the context of the syllabus. So when you read the sections in the context of what we discussed in the session today, it will become a lot more easier. And also follow the technique that I discussed in terms of looking at reading selectively, and that's going to help you assimilate things a lot better, right? So that's going to help you overall in your preparation. So with that, we come to an end to this particular session. And I wish you a very, very productive week ahead in terms of your preparation. Keep working hard, but more importantly, keep working smart. Keep revising the concepts that you've already gone through. And most importantly, the amount of stress that you take has to depend on what kind of a person you are. If you're someone who loves to take stress and it improves your performance, then be my guest. Take all the stress that is required. But if you're someone who underperforms under stress, then it's important that whenever you're feeling stressful, you relax, you calm down, you take a deep breath or maybe even take a break, go out or do whatever you like and then come back and restart your studies, right? So that's very, very important because you cannot get undue amount of stress at this point of time. Yes, it's a competitive exam. Yes, it's going to be tough because a lot of people are preparing and a lot of people are working hard. But if you have faith in your preparation, if you stay focused, if you work through the tips and techniques that you've discussed in the session so far, then it's going to help you crack this particular exam, right? So stay strong, stay focused, wishing you a fantastic day and a wonderful, wonderful week ahead. Until the next session, this is Ravi signing off. See you guys.